I was told that I can't do that on Friday afternoon, so it's been out of my system.
So welcome, folks. This is House Corrections and Institutions Committee. It is Tuesday, February 24th. We're beginning our week with trying to grapple with the pretrial supervision program and trying to get our hands around how we move forward with this. Do we do it? Change the whole structure of the pretrial supervision program in terms of who are being supervised, what's their risk level? And if so, then we have to look in terms of the level of supervision that DOC would be required to do. Do we try to connect this with the expansion possibly of the accountability docket within our court system? So that's what's before us. And we do have a new draft, 1.1, that was dated the 17th of February. And it doesn't really address some of this. It addresses some of it in terms of trying to get more people into the supervision program by taking out two requirements for them to participate, which one will be violating a condition of release to begin with, or the other, they have 5 or more pending dockets. Doesn't talk about the risk level of folks. It's just sort of arbitrary 5 or more dockets and you would be eligible for this program. And according to testimony that we've heard, is that the defendant, it's up to the defendant to decide if they want to participate in this program or not. It can be recommended, but ultimately the defendant would be would need to say yes to being in the program. It's voluntary. It's not required, it's voluntary. So that's what's before us. Questions?
Yeah, I think I'm dense, but I'm having trouble seeing the plot overall, I think, because it depends on, like different people you talk to, it's to increase public safety or it's to reduce the number of people we have incarcerated being detained right now. So I don't even really know what the purpose is at this point. I think it's good we have more clarity on the number of positions and the money. That's the first step. But I almost feel like, when Jay Johnson was in here, I always feel like I need to go back and see what's the proposal really. And just like you're saying, Chair, how does it intersect with the accountability court, and how is it separate and can stand on its own without the accountability court? So to me, those are like big questions, right?
Big questions.
Yeah.
Kevin?
To me, what I thought we were doing was, I thought the 5 docket was identified as a way to break the log jam in the backlog in our courts.
That was the pilot project.
That's the pilot project. It wasn't to exclude people, it's just that these are the highest priority ones because the paperwork's getting balled up and slowing everything down. And that's why the 5 dockets. So I'm all for opening it up so more people can participate. But with the idea that we want to prioritize those that have the most dockets, so we drain the swamp, if you will, in addition to providing supervisory help so that the people can succeed if they are out instead of being incarcerated. So that's the dual program in my mind of what we're trying to do is the most efficient way to drain the swamp of paperwork and get people the help they need by hooking them up to the services that are available. And that's where these additional people would be sitting in on the accountability docket or pretrial days and doing things in parallel instead of series. The series has given us a backlog that we can't get rid of.
So I don't want to confuse the 5 dockets more. For the accountability court, that was a standalone 5 dockets or more. When we did the pretrial supervision statute, it was 2 years ago. And we weren't sure if there was going to be a whole rush of folks into the pretrial supervision. So we set up some parameters. And there were 2 parameters. If someone violated current conditions of release, they could qualify for pretrial supervision. Or if they came in with 5 pending dockets. That was not connected to the accountability court 2 years ago. That was for the pretrial supervision. When the accountability court was agreed to through negotiations with the mayor from the city of Burlington and the governor's office, and then with the courts and the state's attorney and the AG's office, because of the backlog, they hit on the 5 or more dockets. So I don't want to confuse the 5 or more dockets, because one is for the accountability court. Okay, if they roll out the accountability court, we don't know what those parameters will be, if it will be the same as it was for the Chittenden pilot project or not. The pretrial supervision, if you just do the pretrial supervision program, regardless of what happens to that accountability docket, and if that accountability docket doesn't get carried out throughout the state, do we still have that pretrial supervision program? And what does it look like? That's the question. Do we still do it? What does it look like? And I know, maybe I'm putting words into DOC's mouths, but there's an opportunity for DOC to beef up their field staff by 7 possible new folks. So I'm sure they're going to want 7 new people regardless if there's pretrial supervision or not. And that's what we'll have to balance for that.
Forgive me, let me try one more time.
You're right with the backlog, the 5 or more, that was part of the pilot project.
But meld them together, my impression was we wanted to take all the good things that were going in the accountability court and do some of it in pre-trial, and some of it is the additional DOC employee, FTEs being part of, may not be a full accountability court everywhere, but it would be the same kind of idea so that we could get the services to those people. Who determines which ones get to go through the pre-trial supervision first?
Well, if they have the wraparound services, they would not be in the pretrial supervision in theory. So I don't know. I mean, I feel like we're going around in circles and spinning and trying to figure out. And there's a lot of money at stake. There's at least 1.5 million, if not 2.1 million for that. So let's start with the testimony. And I'm going to start with you, Kim, whether you want to or not. For the state's attorneys. I don't know if you've heard some of our discussion here. I don't know if you can help us focus a little bit. You folks are on the ground, you know what you're seeing in the courtrooms. You know what you're seeing with the defendants. So I'm going to turn it over to you. Maybe you can give us some direction.
See what I can do. For the record, my name is Kim McManus. I'm with the Department of State's Attorneys and Sheriffs. When we were in here last, I think the question was raised, how would we want to spend the money if we had the choice, other than giving it all to us? And I had said, that was thrown out there as an option, I believe by Representative Casey. It's absolutely going to happen. And the answer we had given at the time, and I think it's still our answer today, is right now with what we saw, the progress we saw with the accountability docket, we think the majority, if you're pulling all that money into one bucket, the majority of the money would be best spent being able to put up the replicating the accountability docket in the counties that need it. As we mentioned, not every county is going to need that sort of intensive court time. But we do, I believe that Judge Zoney said 6 counties off the top of his head. And we would probably go back and forth a little bit, but being able to roll out the accountability docket where needed and having the support of DOC in the courtroom, we think that's the money best spent. In that, the individuals who pretrial supervision was originally designed for are, for the most part, the folks who are being addressed in the accountability docket. The folks who we are seeing not taking on, agreeing to pretrial supervision are the folks way at the other end of the spectrum, the folks who would otherwise be detained, and pretrial supervision is a step down from being detained. Very different populations, very different needs by the Department of Corrections. To have that level of supervision in the community, it would be a question for DOC whether they have the capacity to give that with the number, maybe with having one in each of their probation officers is enough that DOC can provide that information. But I believe, to Representative Winter's point, if DOC has flexibility in how they use those positions between supporting accountability docket and pretrial supervision, as you decide who you want it to be, that would be, I think, the ideal, so that DOC can shift their person power as needed, depending on the numbers going in. So that's our overall comment. I do just want to reiterate, and I said this last time, I want to be careful that it's not necessarily going to be 1 day a week when these accountability dockets are set up. It might be, again, depending on the county, it might be like Chittenden, 5 days a week initially, and then down to 3, down to 2, down to 1. That's more likely the scenario, or say 3, 2, 1. So again, Department of Corrections would need to factor that in if they were able to be in the courtroom. And part of that is the Agency of Human Services. They were doing the connecting with services. In the accountability docket, Department of Corrections, the benefit of their role being there was being able to talk to defendants up front about the what if. What if I go on probation? What's that going to look like? What if I do a split to serve? What's that going to look like? And defendants really feeling they had that assurance of what was coming, and even potentially who their probation officer might be on the other end. That's where we saw defendants utilizing that the most.
So the goal of the accountability docket, I think we need clarity on that. What is the goal? And this is beyond our purview. This is really House Judiciary. I want to be clear about that. But that kind of figures out how we use DOC in that world. What is the goal of the accountability docket? To clear up the backlog? Or is it to deal with those hard cases? Because those are two different modes of operating.
Yes, primarily addressing those cases. And
cases.
The 5 or more, that there's a reason why those individuals are collecting those cases. One, because yes, the first case is taking too long, so that's part of the backlog, but it was never about just clearing the backlog. It's that the individuals who are picking up multiple cases, they have needs that need to be addressed. And by bringing all the players into the room, AHS, DOC, defense attorney, prosecutor, and having the judge, they were able to deal with the criminal cases, but also address the social issues that are more likely than not causing people to have that criminal behavior. So whether it's because and it's always, not always, but often they're all intertwined, right? But we're dealing with folks who are unhoused, who have mental health issues, who have drug, alcohol issues. If we're able to connect them, and we're not saying that it's going to be one and done, we expect to see some of these folks back, and that's okay. It takes a few times to get this, but while they're out on while they're out on conditions of release and just collecting cases, they're just being referred to services, but they're not necessarily engaging in those services. By being able to dispose of their criminal case and having it part of their disposition, that they are connected with various services and they're actually literally handed off to the individuals, whether it's DOC or AHS representatives. We believe, and what we believed at the beginning and what we saw throughout is that that's working for many.
So you may know more where House Judiciary is, are they still looking at that threshold of 5 dockets or more? If the accountability docket is spread out, is rolled out, are they still looking at the triggers 5 dockets or more?
I don't know if they've spoken specifically about that. I know if they asked us, or if this committee room was to ask us, we would likely, we argue not to have a set number in statute, because what we're going to see in Chittenden more than likely is that, yes, they started with 5. They've been able to reduce that to such an extent that now they can open the doors to the 3 or more, right? Not wait till 5. Maybe it's the 2 or more, that we would want that discretion as we're able to lower those numbers. But again, for those repeat offenders, and we wouldn't want that repeat to necessarily be defined in statute, because then every year we have to come back and ask you hopefully to lower it.
So it almost seems like the accountability docket rollout has not been baked. It hasn't cooked up yet.
Well,
It's not in the oven yet.
well, where is it in the mixing bowl? It's in the mixing bowl.
It's gotta rise
Like a
again.
baker. I don't know where we are.
It's in the oven, but it hasn't been there long.
So there are discussions right now of who would be the next county that would be a viable place to do this next. But of course, this is all then tied to money. So yes, but if we're giving them the message, the signaling that money is going to be available to roll this out, I believe between judiciary, state's attorney, all the parties involved, we will actively roll this out.
What we've also heard is if you roll this out into a few courts, the money's already in the system because those folks are already in the system. So if you designate one day as an accountability docket to move these cases through, it's not going to cost more money because those cases are already in the system. We've heard that in testimony.
I would disagree.
Putting it out there because that's the testimony we heard. Doesn't mean that in reality would happen.
Right.
And why would you disagree?
So simply we'll just choose the judge in the extra courtroom that we need to focus on these cases. If these cases stay in their docket as is, again, they're competing with our violent felonies for court time. And they will just stay and continue to get pushed out and get resolved at some point, but not quicker. So you're spending money on more time. Now, what I don't know, and I'm not a mathematician, is over time, if you paid for the judge and for the extra individuals to have another courtroom set up, do you at some point break even instead of having those cases linger for years? Probably. I wouldn't be able to do that math for you, but I believe there would be the initial cost up front. Absolutely. But at some point that would break even. I just don't know what that would be.
This is helpful, actually. So, like, I think as I first saw it, the 1 day a week would be sort of instead of everything else going on, but it would be the same courtroom, same judge. You're saying for it to work, you need a different courtroom, you need more space, and you need to bring somebody, maybe a retired judge out there in addition. So if it's Mondays, you got a couple of judges working at the same time here, right?
And again, it's going to depend a little bit. That's where it depends a little bit
Yeah.
county to county. But in the larger counties, the other docket needs to keep going, and that judge can't step out to do this. We need another judge to address this. In some of the smaller counties, it might be that there is a court day 1 day a week where the judge could do this focus docket, and the benefit is for the defendant to know every Friday, you're here, or every other Friday you're coming back, or if you miss a court date, you just walk in on Friday, we'll take care of you. Like, there's that benefit. So again, it's gonna depend a little bit on the county.
I'm just wondering, like Washington County, right? We don't have enough courtrooms as it is. So that's a big problem for us, right? That could take us out of consideration. It's
Or just being creative about finding that other
trailer or
space.
something, yeah. It's-
There are spaces around. And we surveyed our state's attorneys to just sort of talk about like, is there an empty courtroom or a space that could work for this? So we'd be happy to help find those spaces.
And you're seeing the population pretrial supervision, I'm going back now, right? Most impacts is not people who would otherwise be released on their own reconnaissance, but people who would be detained otherwise. This is an alternative to them being detained.
That's,
That's my understanding, and I think there is a difference though between Orleans, where it started, and Chittenden. Chittenden, there was, I think, 2 people who overlapped, and I would defer to DOC. They have the numbers, and I believe they said last time we were here, it sort of fell in that 5 or more docket of sort of lower risk, so to speak. Whereas the Orleans individuals who agreed to it were on the other end, that they were more likely, or would, and maybe not detention, but maybe you heard about the 24-hour curfew and chose pretrial supervision instead, had sort of higher restrictions placed on them and chose pretrial supervision, so lesser restrictions. So they were used slightly differently. That's my understanding.
Thank you, Kim.
so we're not gonna solve the accountability for DARPA here. That's over there. They have to figure out. So then that leaves us with the pretrial supervision. If we don't have the dual role of the PMP person, can we continue to stand up the pretrial supervision program? And have people go to it where you're dealing with more than 1 or 2 folks per county? That's the question. So I don't know, Kim, if you want to weigh in on that, from what you're seeing from the prosecution end. Is pretrial supervision on its own cost effective in achieving what we really want to achieve, which at the time was more public safety in the community?
Mhm. Again, I went to law school because my math is not up for med school, so I'm not gonna answer the cost effective, as did most lawyers, by the way. I do believe, the taking out the restrictions to accessing the program, right, is gonna widen the net of possibilities, absolutely. And as I testified the last time I was here, to be fair to the program, it was really up and running for about a year or so when we started getting information from it. So that's a piece. So unclear. I wouldn't be able to tell you how many people would come your way. One thing I did want to point out, and I apologize if there's a draft. It's from did you say the 17th?
Yeah, I don't have that either.
I have February 10th. That was in the folder.
Well, I didn't have all my glasses, so maybe.
Oh,
It's 2
okay.
point, it's 2 point.
It is February 10th.
Yeah.
Okay.
2.1.
Fantastic. I did want to point out one thing in this draft on page 2. Nope, just kidding. Page 3. Starting on line 19.
There is a 217 draft.
What's the number of the draft?
1.1. Oh, so I have draft 2.1. in February.
2.1 has all the highlights. We put that one away.
So we're back to 1.1.
Hillary walked us through this when she was here last week.
2, the 2.
It's draft 1.1. It's H529. We're using 529 as the bill.
Still on the 26. Yeah, it's up here. Oh,
It's 529 because that's the bill that's in judiciary. And that would be the vehicle for the pretrial supervision. Draft 1.1 of H529. It's too many nines. We have 549, we have 559, now we have 529.
Let me just pull that up so I don't say something that maybe is already not in the bill. This may have been addressed already.
So it removes those statutory requirements to participate. And you had to have some multiple violations, conditions of release, and you did in order to be pulled back. And we took that out. You could have right now to have an issue for a warrant of arrest. If they're in the pretrial supervision program, they would need to have multiple violations of supervision. And the change in this draft is that they commit one or more violation. Then they are subject to a warrant for an arrest. If they're when they're participating in the pretrial supervision program.
Do you recall what day last week?
18.
Thank you.
Thursday, was it Thursday she was in?
I also just posted it too today.
Oh, I just found it. Thank you so much. I just want to look at one thing, otherwise I can move along and let Department of Corrections. Nope, my issue is gone. Wonderful.
In your issue, how was it addressed?
How cases are, how DOC is being pulled in to do the assessment. Like, that process, it's been addressed in this draft and I don't want to touch it, so it's good. In an earlier draft, it had been in the committee bill, it was isolated to the Department of Corrections assessing anyone who would be considered for detention. And it was sort of automatic without any of the other players being involved.
And they took that out.
They took that out.
Because
So that's
the
like,
conversation I had with the chair of the committee, it's like, how can DOC assess? And
Exactly.
they don't even know the person.
This version, this is great. I apologize, I had the other version on.
So that was what was taken out.
Perfect. So I don't know if I give you any direction, but that's
You tried.
what we have.
Yeah, we're just you heard our conversation, we're grappling.
Yes.
Do we continue with the supervision, pretrial supervision, regardless of what happens to the accountability? Do we set up this pretrial supervision, thinking we've opened up the gates a little bit, there isn't this logjam necessarily of people not getting in? We roll it out statewide. In order to do that, we have to hire some more folks. Don't know if hiring 7 to make 12 is the ideal number or not. And also one thing, Kim, you were saying, it played out differently in the counties, where one county may have high-risk folks go there. So then that's played out a different way in terms of supervision versus other counties. There may be a group of folks who are lower risk and don't need as much supervision.
Right, but who need more support, right? That sort of supportive helping to access services piece. And so I think that is the question for the Department of Corrections is, could they handle either end of the spectrum? Like, can they resource both ends? And obviously there's a limit at some point to that. But again, those are two very different types of supervision. So whether or not they feel like their supervising officers would be able to do that. And again, I think there is a place where pretrial supervision can be helpful if DOC has the resources to provide. If we're saying to a victim, this person may have been detained, but they're not going to be because they're on this strict pretrial supervision program. If DOC is properly resourced to provide that high level of supervision. That is a plus, I think, for a number of the victim, the defendant, but only if TMC can truly give that level of supervision.
Talking two kinds of risk. If there's risk to the community, I personally don't see that individual as being appropriate for pre-trial. If it's risk to the individual because they can't comply with services that are being offered, they need parental supervision. If that's the high risk, then I would agree. So that's where I see you saying both ends of the spectrum. If they got 5 dockets because they just can't get to the court or they can't get to their doctor who's helping them or whatever, that kind of risk. But so I think that's fairly clear. We wouldn't put someone on pre-trial if they were a risk to the community.
Well, unless the court decided that the supervision in that program would mitigate those public safety risks. The example I'd given last time, a person accused of driving while intoxicated wouldn't necessarily be in this program, but maybe it's their 4th or 5th time. So maybe they would be. Then there's specific conditions and maybe they're being tested every day by their supervising officer that they're not drinking, right? Like that's then potentially mitigating the public safety issue. So, but to your point, it would, if the program could address the very specific public safety issues that would have us concerned, then it would be more utilized.
And if they're being detained because they can't make bail or the bail is so high, that indicates to me that the court thinks they are a risk to the community.
Risk of flight.
Risk of flight.
It's risk of flight. Bail is risk of flight.
Okay, I'll.
But again, that's
Let me see if I
where,
get that through my head.
and I don't want to make the Defender General's arguments before him, but that's where a defense attorney would argue, you see my client as a risk of flight, can we lower this bail? And we'd put him on pretrial supervision. Supervising officers checking in every day, is driving by his house, et cetera, et cetera. That would be the argument for it. But again,
Through my head.
If that was resourced to do that, that's a lot of in-person work.
Bail is risk of flight by our Constitution. So I am going to shift to Matt Valerio, our Defender General. Usually Matt comes in towards the end, and I looked and Matt was here, so I want to give you a chance to go before you have to wait out everybody else
Well,
to.
there are a lot of people tugging at me today.
So I just want to give you a chance.
I will say that what was posted on the website for me to comment on is not what you're talking. So I have no idea what that says. Whatever Kim had the benefit of just looking at, I've not seen, so.
But we're trying
I
to,
can answer a lot of questions about what you were talking about.
what do we do with trial supervision?
I mean, I know what I'd do with it.
What would you do with
I'd
it?
pitch it.
We were there about 10 days ago.
This is, I don't think you get bang for your buck with it, to be honest. Because there are assumptions about how it would be used and where it would be used to kind of fly in the face of constitutional requirements for bail and conditions of release. And as I said the last time I was in, when I was talking about it generally, this is not a program that would be widely used. And it wasn't widely used in the pilot, and it wouldn't be widely used statewide because it would only be a discrete group of people who would consent to doing it. I don't want to give a whole bail conversation here, but the bottom line is bail is only designed, as you said, to ensure appearance. Conditions of release, you have to be put on the least restrictive conditions of release to ensure that you show up and to guarantee public safety. This is a high level of intervention compared to the various levels that could happen on conditions of release. So before you ever get to this point, there are a whole bunch of other things that could happen before you get to pretrial supervision, where you're effectively on probation before you're ever convicted. There were, Bill has written, I had some issues with just relative to some of the requirements, and I don't know what the new one says, so I couldn't tell you. Let's talk about this conceptually first. I don't think you're going to get very many people in it. I also think that we're further along the road with the multi-docket courts than you guys seem to understand. Because we had a meeting on Monday in Rutland regarding the next rollout of it. And every county is going to be different as to what resources they need or what resources are available. And for example, in Rutland, there is sufficient courtroom space, and the plan is to bring down the Superior Court civil judge, who is much quieter there. And they tend to be in every county, to be honest, unless it's one of those counties where the one judge sits in all three courts, like Addison County, family, civil, and criminal are all one judge, right? But Rutland has family court judges. They have a civil court judge. So the civil court judge for one day a month or every other week is going to come down and handle that extra docket. So it's not extra judge time. It's not extra. It's not a space issue. My guess is whatever extra money is going to be spent on two things. Number one is either court security or staff, and the other is going to be what we decide to do, what the Defender General's office decides to do, like what we did in Chittenden County, which is provide a liaison between whatever happens in court and whatever services are required, so that we can make sure that the clients get to where they're supposed to get to. If you're having trouble showing up in court, or you're having trouble complying with conditions of release because you have mental illness, you have substance abuse problems, you have both. You might have any other number of problems, childcare issues, transportation issues, you name it. But the social work aspect that we provided, while making sure that the services were appropriate in Chittenden County, was, in my view, a key to making sure that what went on there worked, being able to clear those dockets. So
who set all of that up for the social services to be there for the person in the Chittenden project? Who set all
what the part that for me?
Was it all the defense counsel that set that?
Well, no, we were the ones who, they had, administration had AHS, and I think they had an agreement with the Howard Center. And I don't know who everybody was on the AHS side who was actually providing services or directing people. That was administration side. Also, the Department of Corrections was in the room every day, which was huge. That doesn't happen normally. And so the fact that did happen helped make everything work. I don't like the term the warm handoff, but that's, we had a social worker and licensed clinician or clinicians with Therapeutic Works, who we contracted with for the period that this court was. It actually ends at the end of February. So there's a carryover for 30 days after the court ended, the full week thing. And they made sure people got where they needed to go, and then provided actually after hours services for, drop-in centered food, coffee, someplace warm to go when it was freezing out. And that's what they did. And so You can't replicate exactly what went on in Chittenden County everywhere else, but you don't have to because every county has different needs. Washington County has a whole bunch of unique needs that have, it's different. Rutland is a good place to try to do something right now because they have a jail right next to the court. I mean, it's 200 yards or whatever from the court to the jail. So the transportation issues aren't the same as Washington County, for example, where you're bringing people from, St. Johnsbury or whatever, or the women's facility or some in Springfield even. Washington's a different thing, but every county is different. Some may not be amenable to doing it at all because of the barriers that are there. But I think you'll get a lot of bang for your buck with that program as opposed to this. Now, on the one hand, and I feel like I'm a broken record compared to what I was saying this morning, talking about work crew. Do defense lawyers tend to like it? Yeah, because it's another tool in their box that they can access when they are trying to get stuff done for their clients, resolve cases or whatever. Would this be another tool in the toolbox for defense counsel to access for those clients who've done every other thing and not succeeded, and pretrial supervision would be a place for them to go that wasn't jail? Sure. I don't know that you're going to get much bang for your buck overall doing that. So this was conceived at a time, Dick Sears had this idea. He was working through Council of State Governments, did something like this in Illinois. They've done things like this in Massachusetts, done some of these things they do this in federal court. Probation is, for example, and pretrial supervision is attached to the court. It's actually, that's where the basis of power is, so to speak. Same thing happened in Illinois. We don't have a Department of Corrections or probation and parole that is attached to the court. It's its own entity. So some of the things I saw in the original bill where, a probation officer would advise the court that somebody violated something. And then I saw a version where it was like they could advise the state's attorney or the court. There's never any good reason to advise the court because they can't do anything. It would have to go through the state's attorney, for example. But this is like the weeds of if you decide to do it at all. But to me, I saw the clearance of the dockets happen in Chittenden County. I saw people get connected with services in the first instance, at least in Chittenden County. I saw what it was trying to accomplish began and was working there. Now there are issues with that we're seeing even just a couple of months into this that are, but it ends up, that does what it is intended to do. And I don't know that pretrial supervision aids anything that the current system plus the segregated docket, multi-docket thing doesn't cover. It's a little teeny bit for those unique people who might access it, but I don't think you're going to see a lot of it. And that will also be different county to county, as Kim said. I think that you are going to have some state's attorneys who are going to focus on, the high risk, high need people, and then you're going to have some who are, actually probably pulling people out of like diversion to do pretrial supervision kind of thing, depending upon how they look at how it's supposed to work. And we've seen this before with other dockets. You might remember, I don't know, 10, 15 years ago, the Sparrow Project in Windsor County, which by the way is still on the books, but no money.
Same thing as the accountability docket, pretty much. It was
No,
pre-trial monitor.
Well, it was actually part of the resolution of the case. So it wasn't and little bit different, but they have the whole thing is to try to connect people who are amenable to services. That's what we keep doing, pushing that. And for some it works and for some it doesn't. You know, I'll do preliminarily on the 3B, so to speak, docket out of Chittenden County, resolved a lot of cases. Now the Prisoners' Rights Office is seeing a lot of furlough violations because the people who couldn't comply with conditions of release when they were on conditions of release are not able to comply with conditions of furlough and probation and other things while they're post-conviction. So we're seeing those start to come back already. Didn't surprise me. The thing is, it's kind of off the docket now. It's in POC's hands, and it's coming back to us on the probation side and on the furlough violation. But you don't have cases that are 4 years old either. So it's a different type of control of that group of people and docket. So I think it'll take some time to really see, you know, how it sugars off relative to like recidivism and you know, can we kind of help these folks at all? You know, we can get them off our docket. That's step one. You know, that's just step one. So, you know, I said basically the same thing last time I was here. I don't have the new version, but does the new version still have the thing where if you violate something, the court shall issue a warrant?
Yeah, the current law is you need multiple violations. What the draft before is commits multiple violations of supervision requirements or has.
Does it say the court shall issue a warrant?
May. It's still a may. And
The one
instead of multiple, it's one or more violations.
yeah, that's the law anyway.
Right.
On what I saw on draft 2.1, page 6 and 7, right at the top, says shall issue a warrant for the arrest of the defendant who meets the criteria.
That's gone.
Yeah, because I don't think you can do that.
That's gone. Because we're working on 529, which is in Judiciary Committee. That's the language we have.
That wasn't all right.
So what it takes away the statutory requirement for defendants to have
Or more.
charged with violating condition of release or 5 or more dockets, pending dockets, gets rid of those 2 items, which is then open to more defendants. The pretrial supervision program will be open to more defendants.
It's something that'll be recommended because you're going to go through this progression of, you know, what type of violation is it? Is it, you know, a technical violation or is it a new crime? You know, and, you know, what's the severity of it? You know, all of these things that would be all covered under our bail law as it is. The difference is that if this existed, once you kind of rise up the level of stop screwing up, now you get to this group, a small group of people who would be part of this program. I don't see that it necessarily changes kind of my analysis of it.
That's what we're grappling with, Mark, Matt. It's like, do we keep this program in the current structure? Do we try to change it in such a way that when the accountability dockets are rolled out, that we have DOC folks, that person sitting in the court that particular day, and then coordinate with the Department of Health or Department of Mental Health or all the other folks to provide wraparound services for this person while they're in the community awaiting trial.
You know, this concept floats around in all kinds of different, you know, sort of forms over the last 20 years. And, you know, Sparrow Project is one of those things. If you remember the RIC program in Chittenden County, that started with a grant that myself, TJ Donovan, and Andy Polito, who was the corrections commissioner at the time, we got from Senator Leahy for $250,000. And there was a screener, there was a lawyer attached for TJ's office, and there was a law enforcement officer who would check in on people who got screened into, and the whole idea was to connect these people with wraparound services till the money ran out. And then, then we try to do it again, and it did call it something else. Yes, there are people who need services. We know that. We keep coming back to that. The question is, at what level are we going to, what level of severity are we going to get to before we ask them to do that? And what is the best way to make sure that they actually take? It hasn't traditionally worked well where just the court says, you shall do X, Y, and Z, because they walk out the door and they're trying to figure out, where am I going to sleep that night? And they're not really worried about, where's my screening for my needs assessment? The screening is, I need a bed for tonight, and that's as far as it goes. And that's, we're seeing some of that post resolution of these 3B docket cases in Chittenden County. But, they're along the road, they're quite a ways along the road as of Monday in Rutland already. I mean, it's going to happen.
So if it happens in Rutland, you were there in this discussion down in Rutland, what would be the role of DOC?
It's just, as I understand, it's the same kind of thing. They would be at the table one day a week, having somebody there to assist in the resolution of these cases. So you're not chasing around a caseworker or the like to try to figure out what the impact of this sentence or probation suggestion or furlough sentence, what the impact's going to be, what can we do to make sure this person, just like in Chittenden County. One of the things they also did in Chittenden County, like some of these furlough sentences, you'd have a zero minimum. And oftentimes you get a zero minimum, you still have to do some jail time before you actually, figure out how to program you out. But that didn't have to happen, because all of that was resolved by the screening, by what you did when all of the parties were together, and it got people onto the treatment without dealing with facilities and that kind of thing.
Then their status was on furlough out in the community.
Some of them. It's not all of them. I mean, some are just probation cases. I mean, 30-something% of the cases were dismissed. There's a whole bunch that, all kinds of things, all of the dispositions that you could, there was nothing special about the dispositions overall. The bottom line is everybody was together making the decision at the same time. And so that got the case resolved, rather than saying, oh, I got to figure out what the sentence means. If I talk to somebody from DOC, everybody's on the same page, understood what it was supposed to mean, because they're all in the same room making the deal together.
And that's the key.
Yeah.
Any thoughts, questions of Matt? Because I do want to get to DOC. Does this help? Does it make it clearer where we go?
Yes.
It's put a couple of Jersey barriers up on the thing.
John?
I mean,
Just quick,
Sorry, Matt.
Sorry, Matt.
Apologize, that's the high point of my day this
Poor
morning.
man.
You said that it was
Now you're breaking up.
in Illinois. Oh, am I? Okay.
Well, now you're
Don't worry
okay.
about
No, you're okay
We
now.
go back to what it.
Okay. All right. But you had said something about Illinois working. Do you have data from them? Or can we get data to see how it was working there?
well, what I do know, and excuse me for not looking at you, maybe I am. When Senator Sears at the time brought this back as an idea from his work with the Council for State Governments. Illinois had just implemented it, and he thought, boy, that's a good idea. Why don't we try something like that? And that's why it was a small thing and it was a pilot to see how it would work. Illinois was one example. The feds is another example. Massachusetts has something similar, but not exactly. The difference with all of these is just how are they connected with the courts, as opposed to an independent Department of Corrections from a probation standpoint. You know, I'm sure that I don't know that anybody ever followed up with Illinois to see what happened there, only because we were probably 10 minutes behind them in implementing ours. It was like conceptually the idea, and it probably is a good idea because we keep coming back to it over and over and over again.
Form.
Yeah, in different forms.
This is wraparound services.
Yeah, and to try to get people out of whatever cycle that's
Right.
causing them to be, you know, violating the law. And it doesn't always work, and it probably doesn't even work the majority of times. But, you know, if you can reduce the number of people who are coming back into the criminal justice system by like 30%, huge win, massive victory. You know, you can't be looking for like 90% success rates or 50% success rates. You got to look at these things incrementally. What does this program do as a piece of resolving this problem? What are the things we're trying to do at the Department of Mental Health that are resolving a portion for that thing? Well, how do we deal with the drug side? Big issue for us that we don't deal with well is co-occurring disorders, because we have no place in Vermont that treats those folks. We have to go to New Hampshire if we're going to actually do residential treatment of those folks. So that's like an ignored, but we aren't adequately set up to deal with those folks. So we deal with them inartfully.
Yeah, piecemeal. Connor?
Yeah, Matt, just looking back, so at one point you were saying like somebody has to agree to do pre-trial supervision, right? And I think I'm just trying to wrap my head around how is that preferable? I could see it being preferable to being detained, right? What are some other options? You're going to do pre-trial supervision, or else what? What are some of those other things?
Well, you'd probably be held on bail, or you'll be held without bail. I see this as the step just before. Now you're going in before your case is resolved. You know, it's the highest level of intervention with a person short of going to jail. So it's high on the scale of us messing with you.
So it's pretty much that or jail.
That's what it seems to look like. Now, there are going to be some people who might just say, no, I want these services. This is the way I'm going to get them. And they'll do that. I don't discount the fact that there might be a few who do that. I think it'd be not so many.
So for someone to say this increases public safety?
It might, but it's incremental, you know, and it's for a small number of people. Like we can do a lot of things that incrementally on a small level impact public safety. I think this would, but for a discrete number of people.
Thanks.
Yeah.
Any other questions of Matt before we move on to DOC? Thank you, Matt.
Yeah, thanks.
Your testimony
Somebody-
was helpful.
I heard that there was some rumor that you might want me back here tomorrow.
Well, we're gonna have the judge tomorrow, Judge Zone, to
Yeah,
talk
I know
about this. And we have to make a decision on where we're going with this pretrial supervision. So I'm not asking you to be in the room, but we may have questions that pop up. We've really got to get off the dime and make a decision. And I just didn't know how this afternoon was going to play out.
Yeah, okay.
And we couldn't have, Judge Zone wasn't available today. He's available tomorrow at 1:00.
Yeah, I have to tell you, it's a little bit difficult for me this year. Not that this is your problem. I'm the only one doing this stuff. And in the last month, we've had multiple, like 20-person busts in Bennington and in Windsor County. And yeah, cut it out. And you know, so I literally had dozens of people sitting without lawyers that I had to find pull lawyers out of Chittenden County to come down to handle cases in Bennington County. And similarly in Windsor County, just because they arrested they arrested Hardwick or something, the entire time, all at once. And they all need lawyers. So, to me, some of the times where I might be sitting around listening to people, not that that's a bad thing, but I got to make sure these people get lawyers. That's number one
You
job.
want to be respectful of your time, but just want to make sure you're in the loop and whatever decision we make.
I can, yeah, no problem.
Matt, or I should say Sean, don't say goodbye to Matt too loud. You scared him
I didn't know there was somebody there. I thought it.
right on your
He's always
shoulder.
watching.
Watch it on your back. I mean, you don't feel obligated to be here tomorrow or to listen.
I might be.
Might be.
Just depends how, I think I'll have most everything resolved.
I'm sorry,
So your
Ben.
tone implies that you're not at all obligated.
I appreciate it. And you can all, and you have my cell phone, just call
Yeah, Zoom is available to you too, and
Yeah.
YouTube if you can't make it. It's just, we've got to make a decision because I know Martin is holding off on the bill.
me. Yeah.
And I don't know where we're headed. If the committee members know where we're headed, let's go there. But I go back and forth between all the options.
Challenge.
Well, the thing is, it's not necessarily it's not a wrong answer.
Right.
That doesn't help.
Well, it's not a wrong answer. I look at things, and I've done this within the DG's office for 25 years, is, where do I get my most bang for my buck? And, I figured that out kind of with what I do. I'm limited compared to the stuff that is going on here. So part of what I look at it is, where are my clients going to get potentially the best result? And so, I made a decision. It doesn't mean you can't do everything if that's what you want to do. But I think you'll spend a fair amount of money for a relatively small amount of people. That's all I'm saying.
I just one question, and this is generally off topic, but how often do your clients have delays in adjudication because of difficulty in transport to the courts?
That's been an issue. That's been an ongoing issue. It's very interesting to me, for 200 years, one way or the other, we brought people to court. We had the pandemic, and all of the infrastructure that we had to bring people to court disappeared in 2 years. Now nobody owns a van anymore. No, it's unbelievable to me. And to me, it absolutely, you just hit a little nerve for me. It absolutely has increased the age of dockets, because people who are being held, in my view, are being held longer, because they don't come to court as much. And the video arraignments alone, they don't meet their lawyers. They don't know who their lawyer is going to be, and they've regionalized the arraignments. So you've got, a lawyer from Rutland is, if they're the ones up doing the regional arraignments, they're arraigning somebody who's from, Brattleboro, who it's never going to be that lawyer. They don't meet with the lawyers in advance. All the things that were promised to us, honestly, about video arraignments, adequate ability to consult with clients before, during, after, doesn't happen. Half the time we don't know where they are. That means we don't have ways to contact them, so we don't know how to figure out how to tell them where to come to court. The only good, is the people who are held. At least we know where they are, but they aren't brought to court so that we can get the cases resolved on a regular basis. They come to particular important hearings, or once you've worked out a deal. But the infrastructure that we had to help move cases that included transports doesn't exist. Now, I know it's very complicated. You might remember that before COVID, we did no less than 4 study committees on transports.
Yep.
Study.
And honestly, every single one of them found that it was going to be more efficient to transport people than it was to do things by video. But this was a thing we wanted to do. And by the way, during COVID, we had to do it. So that was the good excuse to get all this through. But there's absolutely no doubt in my mind that lack of transports to court delays the resolution of cases, and they stay in jail longer than they would have otherwise.
You redirect the money. Transport.
Well, money's interesting. It tends to evaporate.
Yeah, it does.
You know, it's not just redirected. It used to be, it was there. Now it's not.
If money's around, you'll hear arguments on how it gets spent, but you'll never hear the argument that it shouldn't be spent.
Yeah, you know,
It's fungible.
anyway, I should leave before we get. That's the whole transport issue it's a totally separate thing, but it's,
All part of the package.
yeah, well, it's one that really annoys me.
Yeah.
But anyway,
Thank you.
on the list.
Thank you.
Thank you.
Now we'll shift to DOC. I don't know who's coming up for DOC. Who wants to be on the hot seat?
The boss just told you.
Good move.
I will sit here very quickly, not for very long, because it is too hot, but also because I think that both the people with me today have more information than I. So
If you could introduce yourself.
I shall. John Murad, I am the interim commissioner for the Department of Corrections, and I'm grateful to be called, and thank you all for being here
You may
today.
not be grateful afterwards.
We, I think what's important to remember is that pretrial supervision is separate from the accountability docket or the 3B docket or the 5 dockets or more docket, whatever it is that we want to call it. It predates it. It was created under legislative fiat and by a legislation. Fiat may be the wrong term, but it was created by the legislature as a tool. And before those, the accountability court existed. And it has a real purpose. We can discuss the scope of that purpose or what we think the numbers will be or not. I certainly respect the Defender General's assessment about numbers. And what he described was, in fact, what we encountered when we first piloted pretrial supervision in the Northeast Kingdom in Newport. He described a situation in which it was really only used when defense attorneys saw it as a means of keeping someone out of jail who otherwise would have been placed in jail in advance of trial. And the 8 or so cases that we ultimately had in the Northeast Kingdom, I believe 6 of them were cases in which the defense had agreed to it rather than it being something that was pushed by the prosecutors or the court. And it was done because otherwise those particular individuals would have likely been remanded to carceral custody. Nevertheless, it is something that's out there and is able to be used, and it does serve a purpose. There was a reason why the why the legislature created it, and why DOC was supportive of that and worked to put together the program. It's because there are individuals who, while out under conditions of release prior to a sentence, are not capable of following those conditions of release. And we do not have a mechanism for routinely observing whether or not they are following those conditions of release. Certainly, there are instances in which people have given false addresses to the court, addresses that turn out later to be completely made up. There are examples of people who are not following curfews or requirements to stay at certain locations during certain hours. And the only way we currently know that is when those individuals are incidentally encountered by other law enforcement. So in other words, they are supposed to be under a curfew and only at a certain residence during, they can be at work and they can go to court and they're allowed to go to doctor's appointments, but they are not supposed to be out and about in any other way. And they are encountered out and about by law enforcement, whether it's because they are actually causing a ruckus or committing an unlawful act, or whether it's because they're with people who are causing a ruckus and potentially committing unlawful acts. and they get identified police run them and say, oh, you are supposed to be at this location and you're not. Ditto, a person who gives a false address and says, I will reside at this location. And the court says, good, you shall reside at that location, only if that person then is in one way or another encountered again by law enforcement, and law enforcement says, well, why aren't you at this address? Holy smokes, this address doesn't exist. Are they held accountable for that? For certain individuals who are consistently unable to abide by these kinds of conditions and who are having real problems with these rules, I don't believe that kind of incidental encounter is sufficient. I think that we owe it to the community to ensure that if they are going to be released, that somebody be keeping them, as it were, honest about the conditions that they're supposed to follow. And I don't believe that there is I'm not an attorney, but I don't believe, in my experience as a law enforcement officer and in this role, that there is a constitutional issue with that if it has been ordered by the court and understood by the parties that have agreed to it. It is also exactly what we expect of them now. There's simply an additional level of assurance to make certain that the people are adhering to the rules. It is not going to be a large population almost anywhere, but it is a tool. It was used 3 times in the process of the 3B courtroom in Burlington out of 79, I think, total. I believe the numbers were about 79 total individuals that went through that court. 66, I think, of those individuals ended up being in DOC custody in one way or another after the outcome of their case. In other words, 10 or so were dismissed, perhaps in interests of justice, perhaps because they were determined not to have done what they had been accused of doing on all 5 dockets. Others were, there were a handful that were held to be on orders of non-hospitalization, et cetera. But 66 ended up having some kind of resolution that resulted in them going under either custody or supervision of the DOC. And of those 66, 3 ended up in this, 6 ultimately ended up in pretrial supervision, and only 1 is currently there now. So the other 6 went into one of those other resolution buckets. So it's not tremendously high volume, but it was a tool available to that 3B court. I don't mean to muddy the water that I tried to clear at the very beginning by pointing out that these 2 things are separate, but it's a tool that will be available that is available to other courts as well. And the rollout of it across the state was the vision of the legislature and of the department long before the governor proposed the 3B court in autumn of 2025. So with that, I'll certainly take any questions, but I'm probably going to end up deferring to Gary Marshall, who is our Deputy Director for Field Services and knows a ton about not only the history of what this body and DOC did to create the program, but also how we've been implementing it and its efficacy. I'll simply say in closing that I do believe in this. I do believe that it's a good tool for us to have. It is not one that is going to significantly affect the workload capacity of our DOC teams in the field as they currently are constituted. I do think that additional personnel are helpful for it, but I also recognize that in all likelihood, the volume in most counties will not equal a single individual caseload. That individual will end up having other kinds of things in his or her caseload. But having this tool available to us is important, particularly in a system where, irrespective and separate from the backlog issues, we have individuals who we do not wish to incarcerate, and we have given multiple opportunities to avoid incarceration, and they have failed those again and again. And we need to have one more tool before we actually do incarcerate. Absent this, I believe that those individuals should probably be incarcerated while they are awaiting trial, because they've proven that they cannot abide by the rules that have been given to them. So if we don't want that, I think this is an excellent way to prevent it.
Questions? Before Connor.
Yeah, might be more a Gary one, Commissioner, because just want to talk like caseloads a bit, and 12 is a pretty specific number to land on. I could see one for each field office,
So
right?
Connor, Gary will come on.
Yeah. So shall I?
Oh,
Does anybody else
trying
want?
to get you off the hot seat.
No. I'm happy. Thank you very much. Thank you. But before I go, it's your prerogative, ma'am, not mine. But does anybody have anything for me? No? Okay.
I think we're ready to train.
Awesome.
transition here. Come on up, Gary.
Sorry to launch right into the question, Gary, before you get settled. That's
It gives them time to think.
yeah, so it's 12 positions, but we have 12 field offices, but obviously there's bigger needs in each field office, right? And I think one of the things I'm struggling with is for this to be a success, you know, we need to have some metrics on it. And those metrics entail coming up with some guesses. Like we think it's not going to be too many people it impacts, but we have to have like a sense of why do we have 12 people there to accommodate this population, you know? It's
Gary Marwell, Deputy Director of Field Services. That's pretty simple. It's one per office.
Yep.
So that's basically, we have 10 probation parole offices and 2 satellite offices that have small populations. I think it would just be easier if people are allocated to a specific office to have an officer there so they don't have to travel unnecessarily. That'd be very hard. Like if you're having to travel 2 hours to see your pretrial officer.
But couldn't Chittenden have like a much bigger caseload for pretrial supervision than one of the smaller ones, which could be like 8 we were talking, you know?
Yeah, I think the problem is that, you know, like we talked about this last time, we don't control the inflow. So the theory we had was that initially we would get a large influx because like I talked about last time, we were looking at, you know, potentially 1,000 people that might meet the criteria who had dockets pending. And we were expecting that to be pretty robust. To the commissioner's point, you know, it looks like it's going to be received at a lower level. That changes how we'd use the resource. You know, we wouldn't be using, you know, when you have, so to draw a comparison, we have what's called telephone reporting or administrative POs, and they mostly do low-level people that are on for low-level crimes, non-violent crimes, and they have large caseloads. They can have up to 150. That is so they can facilitate basically making sure that people aren't getting in trouble, referring them to services. They're not really meeting with them. They're mostly just kind of checking on their case and making sure it's progressing through supervision. If you're looking at a smaller caseload, then we can use that resource in a very different fashion, more similar to like the FACT model in Burlington, where you're meeting with them more regularly. You're probably using intervention skills that we train people in. It's just, you get more bang for your buck when you have a lower caseload.
Mm-hmm. So generally, do you think throughout the system, there's a need for lower caseloads? I mean, that almost resonates with me more. It's like, we've got really high number of caseloads. We need more people.
Yeah. So, I mean, if I were to look at, you know, how these cases tend to have sort of like a trajectory, and then they sort of peak in instability and then they sort of even out. I think people that are in a pretrial circumstance are typically in a more unstable place in their life. The evidence shows that pretty clearly, like the tool we use, the Whereas pretrial tool. You know, so a high-risk individual in that tool we were talking about risk earlier. What that tool evaluates is the likelihood that they're going to fail from the program, so just not be able to succeed in pretrial. That usually results in, you know, being bounced from the program in some fashion. In some jurisdictions, that means going back to prison. The next thing it looks at is the likelihood that they're going to violate one of their conditions pretrial. And then the last thing is that they commit a crime. So if somebody with a high risk score, it'd be like a 29%, 15%, 17% in those categories. So that's a pretty high rate that the likelihood that they're going to pick up a new crime. So that's how I look at it. Like we talked about this last time as well, is my thought is that success would be if they complete their pretrial circumstance, they adjudicate it. However they adjudicate it, whether it be dismissed or they're sentenced to probation or something, and none of those things happen. So if we can engage with them in a fashion that helps that to reduce those numbers, then I think it's a success.
Thanks, Jared.
So in order to achieve that, can some of this be absorbed by the current staffing in some of the field offices? You need to place one new person in each field office because we don't know what the numbers are going to be if we continue with pretrial supervision. So could this work be absorbed by the current staff in some of the offices?
Theoretically, in some of the offices, it could be done, but the problem we have there is that we have caseload caps statutorily in those offices. So if they're at cap,
The high risk with a cap.
the risk management. That's really more, the risk management POs are providing more what we're talking about here in terms of the level of engagement with a highly unstable
So
population.
you're saying what's required in statute for the caseload ratio would be.
Yeah, Yeah,
We could look at that ratio. We could have maybe a carve out.
well, if anything, I'd say that ratio is dated.
Yeah, it's
Because the
very
level of
dated.
intervention that we provide now is higher than it was when that was established, 10,
20
15
years
ago,
ago.
something like that. Yeah. Yeah, so I mean, and my officers told me that. And I'm kind of going off of the FACMO, because it's the closest analog in our system. And I've had the probation officers that were assigned to that tell me, that we put 20 as the cap on that, and that was just sort of our choice. And they're telling me that really it's more like 12. It's a very, very unstable caseload. They struggle with getting to court. They struggle with, we're talking about, they get in arguments with their neighbors on a regular basis, and our POs are going over them to kind of mediate between them. They're engaging with them just to keep them in their residence, going to doctor's appointments, basically keeping them from falling apart completely. And that's probably what you're dealing with if you're talking about people that are being referred by the court to something like this. At least if they're in that high category, that high risk category.
What if they were in the low risk category? They just need kind of like a weekly phone call in or a monthly phone call. What about that?
Given the nature of what we've seen, given the level of instability, we're talking about the people that have multiple dockets, those are probably higher risk. Those are probably higher risk because they're already looking at a violation of conditions. So they've already kind of bumped into that
You did
category.
away with that.
I don't know if they need an intervention.
That's part of the proposal, to do away with that.
Right.
That there isn't those violations of conditions that they've already done, or they have 5 or more dockets. The proposal before us is to do away with that. So then there'd be more folks, the thinking is might be more folks eligible for pretrial supervision.
You could put more people in it. I don't know if they need the intervention. I mean, some of the scores low risk has scores at about a 0% chance of picking up a new crime.
So why supervise?
So why supervise them? Exactly. They're probably just fine on conditions of release.
So if we took the tact of having a dual role for the folks in DOC, where that person would be sitting in the court on the accountability docket and really work with the other providers within the system to coordinate those services. But then there would also, that same person would be able to do the actual supervision of folks in the pretrial supervision program that's separate from those folks that went through the docket, the accountability docket. Is that workable in your world?
Yeah, I think it is. I think because they think they're pretty close. The tasks are very similar. You're going to be talking to the court a lot. You're going to be coordinating resources a lot, which is what the court wants with the accountability court, apparently, which makes sense. I think that makes a lot more sense than having a probation officer do it, because they have a different job and they write pre-sentence investigations. They're doing pardons. There's all kinds of things that they do that is very separate from the court process.
You would need 7 new people to do this on top of the 5 that you've already been allocated?
If you want one per office and you don't want too much travel for folks, that would be because if look at it this way. So if you're in Essex County and, so Guildhall, and the officer for that region is in Newport, I don't know the exact drive time. People here like an hour and a half or something. So I wouldn't want to make people, especially if they're very unstable. We were talking about transportation and things like that earlier. I think that would be an additional barrier that would probably make it harder for them to succeed. And I also don't think it'd be realistic to have the pretrial officer go down there, because if they have people spread out over several counties, New Orleans County, I think Newport to Canaan takes at least an hour, so, and that's.
So where are your field offices up in the Northeast Kingdom?
In the Northeast Kingdom, we have one in St. Johnsbury, and we have Newport. And is Morrisville considered part of the Northeast Kingdom? I can't remember.
No.
Right. So, yeah, those are the.
They wouldn't say so.
No.
No, they're not. So you'd have 1 pretrial supervisor in each one of those 3 offices. You'd have 3 people out. They still would have to travel.
Yeah, you can't. Yeah, it's a rural state. You're still going to have to do some, but it'd be about what we expect out of people now. And there would be, with a low caseload, the expectation I would have to my officers is that they would do some field checking as well. So there'd be some connection there, or, but I wouldn't want them to be traveling an hour and a half to do that.
So the Morrisville field office would take care of Lamoille County, right?
Presumably, yeah, that would make sense.
If I were to ask what the credentials of these 12 individuals, could you give me a little description so I have some kind of idea what kind of background?
I mean, right now it's the same credentials we have for probation parole officers.
So what would that be?
We look for people with case management experience, law enforcement experience. I mean, the bottom tier is not really where we land usually. Like I can hire someone with, say, 5 years of law enforcement experience. I would typically, if I were comparing that to somebody with, say, that and then 2 years of case management experience, I'd more often go with that.
Right.
You kind of need a little of both.
Right.
So, yeah.
Sometimes folks come from a correctional facility and the PUP officers.
It's pretty rare, though. I will offer that's pretty rare unless they're a caseworker. They need to kind of know that they need a certain writing ability. There's certain things you want to make sure they have intact.
Social skills. Troy.
You have 5 positions now, 3 are full. My questions are, is that the fullest it's been? Have you always had those 2 vacancies? Have you done any consideration of why you continue to have the vacancies? I'm a little worried that we're adding 7 more positions at 2.1 million that are going to stay vacant. That's my worry.
I think it's because we haven't figured out what the direction of the pretrial program is going to be. I think that we kind of need to figure out the rollout and when it's operational in each county.
But you've had those 5 positions posted. Yeah.
No.
No.
Oh, you haven't? No.
We've had 2 officers. I believe it's 2 officers hired. I didn't know of actually a third that we had.
Oh, maybe I flip-flopped the 3 and 2.
But I can tell you it's been a little, and I don't blame it, it's been a little confusing because we had a rollout plan and that kind of changed and we're going to have different rollout plan. So, but I can tell you once we decide that we're going to move forward, we would have that position hired. And then we would start working with the court to get a caseload allocated as quickly as we could. If it wasn't being used for pretrial, then we would use it for the court liaison. We'd want that person to be doing whatever we're going to be doing with the accountability court or whatever analog they have in that county.
So you haven't necessarily tried to have all 5 positions filled today?
No, we haven't posted them or anything like that. No, I don't think we'd have to be frank, I don't think we'd have a hard time. I mean, we generally get a good number of applicants for PO positions.
With Judge Matt's hot button of transportation, would these individuals possibly be able to fill that kind of a role?
We generally stay away from transporting people who aren't in trouble. You kind of get into a blurry line if things go wrong in the cruiser.
It's not a good.
We have done it. We have done it in rare instances, but there's liability issues. There's things that can go wrong there. They can, like, do we search them? Like, you know what I mean? Like, we don't want to be searching people that don't need to be searched. We don't want to put people in the cruiser that might have a weapon.
Right.
There's all kinds of issues that can come out of that.
But I am understanding theoretically, you're supposed to have two people transport.
Right.
So if they were one and
That's right.
sheriff was the other, is that still?
We don't usually team up with a sheriff like that.
I think you're talking about sheriff transport, moving an offender who's detained to court.
Right.
And using a PNP person for that.
We don't usually do that. We don't usually mesh up with a sheriff.
That's what you're talking, right?
I'm just thinking of judgments.
Well, the problem is that PNP officer may end up being their probation or parole officer once they're out in the community. So you've got that inherent conflict if they start transporting them while they're still incarcerated.
Yeah, you get into jurisdiction issues.
Just brainstorming, trying to get us someplace closer to something real.
Yeah, that's good, but sometimes there's inherent conflict in some of that. So I could just see one of your staff transporting a detainee and then all of a sudden they're under their supervision once they're out on furlough. And boy, you'd have a problem.
Or they commit a crime in the cruiser and we can't arrest them because they're not under our jurisdiction yet.
Big problem.
It's slippery slope.
Mm-hmm.
So I don't know what to do with this pretrial supervision. I'm open ears here for what committee members are thinking. Well, DOC's in the room. I know the other 2 have left. The judge coming in tomorrow. Where are we here, folks?
we haven't solved the conundrum whereby there aren't going to be individuals subscribed to this program. Even if you remove the 5 dockets or what's the other violation?
Conditions,
Conditions,
violations of conditions.
you're still not going to have the subscription rate. And so I understand the intent and that's good, but I don't think that it's a good value for if you're not going to get. It's my opinion.
Oops. Because there's money on the line here. There's 200,000 being proposed in the budget for an additional 7 positions in PMP, which is on top of 1.3 million that's already there for pretrial supervision. That's your base funding. It goes on year after year after year.
Has any of the 1.2 million been spent?
No, because it's for FY27.
Right.
It's the upcoming budget.
Right.
It's the upcoming budget since we go forward, so we're not gonna know how much of that will have been spent until June or July of 27. It's not in place yet. It won't take effect until July 1st of this year. So what's being proposed for the next fiscal year, which begins in July of this year and ends in June of next year, is 1.5 million. Where the base right now is 1.3 with a 200,000 request to bring on 7 more folks in PMP for an ongoing base cost of 1.5 million. For 12 employees within PMP for the pretrial supervision program. That's what the proposal is out there. So where are we, folks? Do we keep the program? Do we scrap it? Do we tailor it back to saying, you know, let's give it another year or 2 and have dual roles, knowing that maybe Rutland is going to have the accountability docket, give it another year or 2, just and move some folks maybe down to Rutland. Got 3 positions that are filled, 2 that are not. Maybe those 2 that are not target Rutland and use that for the dual purpose of sitting in the courtroom for the docket, accountability docket, but then whomever is sent in Rutland County, regardless, to pretrial supervision does that supervision work as well. I'm just thinking outside the box.
I can offer that to replicate what the Defender General pointed out as being highly effective with the accountability court. We would need a position, like we would need someone to guarantee. We do it ad hoc, really, like when there's an available officer to go down to the court to answer questions and things like that. If there's not a full-time position to do that, it's going to be sketchy whether or not they're going to be able to get down there and do it when it's needed. But if we had somebody who that's their primary function, that would be their primary function. They'd be expected to be there.
So you've got 3 people right now that have been hired for pretrial supervision. Where are they based right now?
There's a position in St. Johnsbury that hasn't been up and running yet, and then the one that we've been using, the accountability court in Chittenden.
So you got 1 person in Chittenden. You got 1 person up in Newport. And then you have 1 person in St. Jay, or that hasn't been filled yet.
I believe we've hired that, we've filled that slot, but we haven't, but it's not up and running yet. We don't have pretrial going as the court, so they haven't been able to do their job as it's been hired for yet.
But the person's been hired?
Yes, but I want to be clear that if the person is not necessarily the person who's going to be doing the pretrial supervision. It could be another case, it could be another PPO who's already there. And in all likelihood, it'll be an existing employee. The individual who's brought aboard it's in that respect, those 2 positions are somewhat interchangeable. And I don't mean to make light of it in that way. I just mean that we are not literally hiring a person who is going in the same way that although we did bring a person into Burlington PNP with the money allotted by the pretrial legislation, that is not the individual who sat in the accountability court was a longer term PPO who's been with us since before pretrial existed. And pretrial, as I said, predated the accountability court, but this individual predated both. But he was assigned to that task and did it really, really well.
So the other person that you hired kind of filled in somewhere else within that field office.
Affirmative. But as long as we are getting
Yeah.
the pretrial done, that's what the task is.
Right, so it freed up a current employee who had a lot more background and
Correct.
experience, freed up that person to go into the court.
Correct. And and function there in a really effective way of being able to know what options were available and having real world experience about these kinds of services are things with which we can connect you. This is how we do assessments. This is how we judge whether or not somebody is a good candidate for not just pretrial supervision, but also for probation or parole or what have you.
You can't be an effective court liaison if you're green. I mean, you have to really know the system. You have to know, because you have to really answer the questions. Of the
Right, you can't have a newbie there.
That's right.
Sean, did you have your hand up?
I did. Can you hear me?
Yes.
Loud and clear.
I'm just struggling because, you know, the budgets are so tight and I totally get where they want to go with this. But the fact that everyone was coming in telling us that it wasn't happening when it was supposed to be happening. And I want to say yes because it sounds like it's going to be great. But then I don't really have a great understanding of all the people that work in all these offices and how maxed out they are or how unmaxed out they are. I guess I wish I understood that a little better. It's just as a guy who runs a business and moves people around to make things happen, I just don't know if maybe everyone is working 40 hours a week and they're maxed out, and I understand I could wrap my head around it, but it sounds like there's two people that are working are not quite doing. I wish I knew what they were doing. Or, you know, and it would make me feel a lot better because $2.5 or $2.1 million is a lot of money. You know, it just is. And I'm just struggling with it a little bit. That's all. I just wanted to share that with everybody.
I think we're all struggling, trying to figure this out.
On average, our officers are getting close to cap because the numbers have been growing up. One of the side effects of the resolving of these pandemic era dockets is that we're getting more probationers predominantly, but the numbers are gradually creeping up. I want to say, don't quote me, but I want to say we're getting around 40. I think that's about the average around the state. Last time I checked,
40
people per officer. So it's getting close to that 45 cap. It's growing. It's going up. I would presume it's going to continue to go up because that's been the gradual trajectory we've seen as more cases get resolved.
You had said that there were 1,000 people you would think that would go into this program or less, 500, 600, 700?
No, sir. When we were initially looking at the criteria, we were looking at the dockets and we asked the judiciary to give us, of the people that are in the judiciary system right now, how many people could theoretically go on the program? Like how many people had either a violation of condition of release or 5 pending dockets? And the numbers we got looked like, I think it was actually a little over 1,000 people that could have theoretically been assigned to this program. So we didn't know what to expect because ultimately it's the court that orders it. So we were looking at, you know, for all we knew, it was going to be maximum amount. We were really kind of flying blind on that one. Because again, we don't control the inflow and we don't control the people that ultimately end up in the program.
So Sean,
Yeah.
when we were working on this initial law 2 years ago, that's the numbers that we had. We knew we didn't have enough money in the budget to roll it out statewide. So that's why we did it limited in 1 or 2 counties so that DOC wasn't going to get swamped. Because we only had about 660,000 at that point.
Right. Yeah.
And as it turns out, we're not having many people of the 1,000 potentials in the system. Brian, you had your hand up?
Yeah, there are too many different things going on. I guess I'll just stick with one of them, which is the idea as put by the Defender General, Matt Delario, is we've used different programs over the decades, and now we're hoping to use this one to tie people to services or to get people into their services. I had thought until testimony, I think from this group, that the short straw, the shortcoming was going to be the folks who provide those services. But it sounds like,
Be that too.
well, okay, but so it sounds like maybe there are some services available, but without this DOC presence in the courtroom, maybe you can't tie folks to those services. So I guess, like, let's get to the question, which is, there's this money that's supposedly going for ultimately a dozen positions. And I guess the question for Gary Marvel is like, okay, suppose it's a half loaf. Suppose there are 6 positions. Suppose you can only do it in some of the counties, and then you could use another portion of the money for services in those counties or something. How would it look if you only got a portion of what we're talking about?
Well, I could speculate.
Yeah.
I mean, I know there's going to be accountability courts. I don't know if they're going to be everywhere. It seems like one of the things we could do is have one of the officers there. I would also want to presume that the pretrial would be tried in those courts as well.
Yeah.
So it would make sense to put them there. If it was something where we were given those positions and then we were being told to do pretrial everywhere, we'd have to regionalize it. You'd have to have an officer that would cover, 2 counties, which I don't think would be ideal. But we'd make use of the positions based on what's happening in that court. So we do our best to make sure that it's getting adequate use for the money that's being invested.
Yeah.
In terms of the service thing, I want to really clear that sometimes it's not a matter of whether or not there are services, although that is often the case. Sometimes they're not the appropriate services.
Yeah.
One of the issues you run into is that it's really, we're talking about a forensic population, and case managing a forensic population is very different from somebody who just simply has high needs.
Yeah.
They might also have high risk. They might also have, there might be security things to take into consideration when you're going over the house and to help them connect. But I mean, that's really what we specifically train our staff to do. And I think we get better results than an average case manager might at a nonprofit, in part because a nonprofit might not have the luxury of keeping someone on their caseload when they've not showed up for 3 times. But we don't give up on people because they don't call back 2 times and then get cut off. We go to their house and we say, okay, that's the problem. It's a very different model, and you're not going to get nonprofit workers generally that'll do that, except in the FACT program where that was part of the contract, and they would go with a probation officer. They would help negotiate the dog that was stolen by the neighbor or whatever the issue might be. So that's an actual situation. So
I like the color. Yeah. Right.
Mary, did you have something?
Well, the difficulty for me is even hearing about the positions. And I understand you don't want someone green going in to be helping place people in the services they need. But I guess I look at it, if we're putting money towards certain positions, then we should get the qualified people for that and have them there. I think where I have seen over the years, we're well-intended, or we think we're well-intended of putting money in positions or whatever here, but then they kind of get shifted here, here, and here. And I know within DOC, it's been tough with at times getting the personnel that you need. So I'm just trying to get my arms kind of around that, is how do we do this, do it right, not shortchange you for the needs that you have to really roll this out to work. But it's still not connected.
I could speak to a little of that. One, I want to clarify, about 700 of our employees are part of the facility operations.
Right.
So, and that's where the meat of our recruitment and retention problems are. We really don't have that same level of issue in the field. So just to draw that distinction, the divisions are.
That's good too.
The other piece is that, so if we're given a position, often what happens is an officer who works within the office currently says, I want to try that because I'm good at it and I know how to work with the court. So what would typically happen is that they would go into that pretrial position if they're appropriate, and then that opens up the PO position to take over their old job. So that's what happened in Burlington. We took a very experienced, very skillful officer and we gave it to him because we knew he would do a good job with the court.
Right, and all of that I understand and get it, and it's the right thing to do, but it was just kind of like, well, we haven't hired this person yet. The money's sitting there and are we going to? And kind of then we're told, well, then it's not, the program's not working or pieces are. And it's kind of trying to pull it all together to make it sensible for you folks to implement it and work through it with the pre-trial folks and but I guess that helps a little bit with what you just said.
Sure. And part of that is we don't want to hire someone and then find out pretrial is getting repealed, because then we have to figure out, do they get riffed? Do they have to go back to their old job?
Understood.
Yeah.
So you've got one person you've hired for Chittenden and one person in Newport that you've actually hired. And then you have a position in St. Johnsbury you're looking to hire. That's
That position in St. Johnsbury there, we're using them for conventional supervision right now because we don't have a pretrial program. We don't have an accountability plan in St. Johnsbury.
So could one of those, Newport or St. J, could one of those be transferred down to the Rutland?
Well, we've already hired that person. So unless that person wants to move, we'd have to have an opening in Newport, and then we'd have to hire, you know what I mean? We can't, we're not like New York where you can just make our officers go to the other part of the state.
No, that's why I asked the question.
Yeah.
Haley, did you want to weigh in?
No, I mean, I agree with what Gary said. I don't think it would make much sense also because we still do have those other two positions that are funded right now. And so if we were to move someone, if we were to use an existing position and shift them over from either Newport or Burlington or St. Johnsbury, we would have to cease the programs in those counties.
But that's then the question that we're grappling with. If we know the accountability docket is going to be rolled out in Rutland, and if we want a DOC person to be sitting there in the courts that particular day, that would be the same person that would be doing the pretrial supervision in that county. So you could move.
Possibly.
Yeah.
Those two positions are not automatically the same. And we don't yet know the Rutland County, if Rutland is where the rollout is, and I don't know that that's been officially decided or not yet. But if it were, yes, as Haley mentioned, we have additional positions that we could hire that we're already authorized for and funded for. The person who, if it were in Rutland or if it were in Washington or if it were in Bennington, we would try to follow the model that we believe worked in Chittenden, which is to assign a person to be at the court when it's in session. And that person, as Gary pointed out, would not be a green person. And so it would be an existing position at the Bennington P&P office or the Washington-Berry P&P office or the Rutland P&P office. And then the idea of rolling pretrial out in those locations would potentially wrap itself up. I mean, I think one of the challenges is that because the accountability model decided to anchor itself to 5 or more dockets in the same way that the language of pretrial supervision did, the two became inextricable, and they're really not.
They're not, right? They're two separate things completely. Well, it's 3:00 and we're supposed to shift to parole.
Oh, good.
Yeah, so I don't for any further along here, but I think we can need some committee conversation in terms of different scenarios. You do have authority for 5 positions right now. You've hired 3, but pretrial supervision is only occurring in 1 county, and I don't know if that's even ongoing.
I think it's 2. It's
state.
and it is still.
So I thought it pulled
Still
it
active.
from there for the Chittenden, for the accountability. board.
Still active.
It's still active.
It's still active.
You just don't want to
Not
sign.
Caledonia, I'm sorry, Essex.
Yeah.
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 So Essex Orleans, but is the St. Johnsbury one for Essex Orleans as well?
Essex Caledonia.
We have, I don't want to make it more confusing. There was one case we took from Caledonia, but predominantly that position is covering the Orleans County Court.
The first one that got hired.
Correct.
And then we've got one in Chittenden and then one in St. J for what we don't know, because we're trying to see if we carry through pretrial supervision. And then then we got 2 openings. We seem to think that the accountability court's gonna open up in Rutland. I'm assuming the one in Chittenden is going to continue, but we haven't heard one way or the other on that.
I think that has been formally discussed. I think State's Attorney George has said that she will keep a presence in that 3B courtroom. It will not be 5 days a week as it was under Special Prosecutor Waite. But she has pledged to keep it going in some capacity. So we do anticipate continuing to participate in that.
So one of those 2 positions could be for the Rutland court, but then that would free up a Rutland PMP person currently that could maybe do the pretrial supervision in Rutland County.
Bureau County Salsa County.
I know, but I'm just thinking, so how we pretrial.
I want to clarify, like, just to make sure, I can't, the 2 positions that are full right now, I can't move them down the road. I can't move those individuals
You've
down.
got 5 positions, you got 3 that are full, 2 that are not full.
Yeah, right. The ones that haven't been full. we
I'm
could-
talking about the 2 that haven't been filled. Could be connected with the rollout of the accountability court. Pretty sure might be happening in Rutland. So one of those, of the 2 could go to Rutland. And that person could be, that then frees up a person to sit in court. And that new person could be with a pretrial supervision for Rutland.
That could happen,
That
yes.
could happen. And then you've got one more position. I'm just trying to think how this rolls out. What I'm seeing is it's going to be a year-to-year thing. Because I don't know if we want to do all 12 for pretrial supervision in all counties, if pretrial supervision isn't something that we support or not. Because I haven't got a feel from the committee yet. Some people feel we don't need it, some people feel we might. And then the accountability docket, I've heard, will go to Rutland, Chittenden, Rutland, Bennington, Wyndham, Windsor. And I think Washington. But it may not happen all in 1 year.
Maybe the judge will tell us more tomorrow.
Kevin,
I think, Commissioner, you made it clear that pretrial and accountability docket are 2 very different programs.
Yes.
yes.
The
Yes.
question is, I think I'm hearing you saying you think that's the only way it is. You can't have one person doing both, depending on the workload or depending on the rollout of the programs or whatever it is. Am I hearing that?
No, I think you could have somebody,
You could.
I mean, to the extent that sitting in the accountability court is a task, and to the extent that as of right now, our experience has been that pretrial supervision is a relatively low caseload per person.
Right.
There is a logical overlap between those 2 for a single employee with the right experience and the right combination of how, he or she approaches this work. So there's certainly room for that, but it's not an automatic overlap.
No, I understand.
Similarly, the rollouts of the 2 things are utterly separate. If this body were to approve the additional funds that have been requested for 12 pretrial, we would proceed with the hiring and the rollout of those irrespective of what does or does not happen with additional courts based on the 3B court model. Irrespective, those 2 things are separate. We are going to do the pretrial across the state, irrespective of what happens with the so-called accountability court. However, if the so-called accountability court is expanded to other locations, there is a logical overlap, as you just pointed out.
Good.
And therefore, it's easy to use individuals in dual capacities. But the 2 things are ultimately separate. Now, that does not speak to whether or not this body chooses to approach one or the other. That is your prerogative, and I don't mean to speak for you or to speak to outcomes. I am saying that if that is the outcome, that's our intention. And with regard to the money that's already been allocated, assuming that that remains in our, in our purview, we'll roll it out to the locations where we think there is going to be the most usage of it. And that would be, ironically, by piloting it in one of our lower caseload locations, that might not have been a place that we would have done it once we decided to roll it everywhere. But if we rolled it, we would look at Bennington and Brattleboro and then Barry and these places where there is a certain amount of caseload, Springfield, and determine which of our 12 offices are going to be best, suited for this if we are only given, if we only have the 7 positions or 5 that we currently have. That's where it were to stop. That's what we would do. But those two things are the accountability core rollout might be a component of a decision like that, but it is not the thing that makes it happen.
So we as a committee need to decide, do we do pretrial supervision on its own, statewide? Or do we do it in some parts of the state and see how it works before we do it statewide? That's one policy decision. The other piece is, do we tie it more to the rollout of the accountability boards and have that dual function for that P&P person? That's what's before us. That's what's before us, to make that policy decision. So on that, I'm going to break because we've been here for a while. We got people out in the hall wanting to come in and talk about parole board.
Thank you.
Gary gets to get off the hot seat and
Thank you.
take a quick 5-minute